Hello and welcome back to the December meeting of the Utah Board of Oil, Gas, and Mining. We'll be starting today's session with docket number 2023-045, cause number 139-173, in the matter of the request for agency action by Jody, Wilcken, Heugly, R.E. Wilcken, K. Wilcken, Cristine Wilcken, Labrum, and Karen Wilcken Farnsworth for an order requiring an accounting and payment of royalties from the Homeland Gas and Oil Ltd. For the Nielson 1-20B1 well. And I will now ask for appearance of counsel.
Assistant Attorney General Andrew Haynes, representing the Division of Oil, Gas, and Mining.
Matt, I'm going to bring you another super source.
Please proceed.
Okay. Thank you. Board, we're here today as a result of the petitioners, Jody Wilcken, Heugly, R.E. Wilcken, Karl Wilcken, Cristine Wilcken Labrum, and Karen Wilcken Farnsworth, filing a request for agency action on September 18, 2023. In this request, they indicated that they owned a leased mineral interest in the Nielson 1-20B1 well, which is located in the southwest quarter of the northeast quarter of Section 20, Township 2 South, Range 1 West, Uinta Special Meridian, and that they were entitled to a share of proceeds, and that the respondent, Homeland Gas and Oil Limited, had failed to pay since July 10, 2013. Their request is they asked the board to set the matter for investigation and negotiation by the division within the 60 days pursuant to Utah Code Section 40-6-9. As a result of this request, the board set the matter for investigation and ordered the division to investigate the petitioner's claims within 60 days of September 27, 2023. After that, the board's order, the division assigned John Rogers, environmental manager, to carry out the investigation and negotiation between the two parties. John Rogers has completed that investigation, and the division has filed a response to the report that he was to give, in which the parties have, to our understanding, have resolved the issue. And because of that, the division recommends that this matter now be dismissed. With that in mind, John Rogers is also here. If anybody would like to ask any questions about the matter or any specifics.
Let's get that off of there. Let's do
Board, any questions for Mr. Rogers?
55, right?
Yes, Mr. Moon.
Okay.
So what was the explanation for the non-payment of royalties?
Okay, there were three issues in the matter. The first was a royalty rate that was not consistent with what the royalty owner felt should be paid. We worked through that. That was a problem with the property being inherited by the trust. All the lots were not included in that documentation, so one was left out. Very minor, but it caused for a different rate to be used. We cleared that up. The amount of oil transported and the amount of oil sold was the discrepancy from what she saw on our website. Homeland did not adjust for that transportation shrinkage, so the number that was transported was less than it was sold, and so there's a discrepancy there. They now have paid on that and have promised to do that correctly in the future. That was due to a lot of turnover within the organization and just some error on their part. So the most critical was the royalty payments were not paid since June of 2021, and again, that was an issue with internal management on Homeland's part. They've corrected that and promised to go forward. Those checks have been cut to the individuals here, and they seem to be made whole. So it was more of a internal business problem with Homeland, and they've corrected that, and they are had new people come in to keep an eye on that.
Okay, thank you.
And, you know, Mr. Moon, you're well aware of how complex royalties can be, and some people don't understand this. When they get it inherited, they don't understand how it works, and sometimes it takes a little bit of education and letting them know how this process works. So it was good on both parts.
Any other questions for the division?
Yeah, Mr. Rogers, does Homeland appear to have the ability and the capacity to continue to pay the royalties going forward?
You mean economically or just
Yes.
operationally?
Both, please.
Well, they have one well in question here, and they do produce out of it. Their economics, I can't honestly say, but they should be able to pay what they need to. The property is going to be taken over by a family member from Homeland, and hopefully they've hired some new people for the internal accounting. So it seems like when this individual got on board, it seemed to get taken care of when they got up to speed. So I think there's a period in time there where there was a little internal accounting issues, but that's been solved, hopefully. And we'll be watching and see how they do in the future. And I obviously told the Heugly, Miss Heugly, that she could contact me if she sees anything that is not appropriate.
Mr. Rogers, excuse me. What's the current daily production from that well or monthly production?
I can't remember, I'm sorry. It was not huge, but it was moderate, I guess. I mean, I should have known.
Less than 100 barrels a day?
Yeah.
Less than
Oh, yeah,
50
far
barrels
less
a
than
day?
that. Yeah.
Thank you.
So I have had questions about this operator from other acquaintances out there. What should I do? Should I have them contact you, or do they need to do this formal?
I've become very
West.
popular with a group of individuals out there. Since they have settled this, I've gotten numerous calls, other people requesting things. So I think, first of all, I like to get to negotiate, work through it, and hopefully get it taken care of before a board order has to be taken care of. And that's usually what happens. This case, I think we needed to move in this direction. But right now, I think contacting the division is the best way to go to see if we can get this moving in the right direction.
Okay, so you have a good contact with the company that you could facilitate that.
Yeah.
Okay.
Any other questions to the division? I've got one question. I believe you're going to request that we dismiss this then, based on this testimony?
Yes, we see no further need to move forward with a hearing on this matter.
And is that dismissal with prejudice or without prejudice?
From my understanding of the rule, because the matter is being resolved, the request then is for the board to set a hearing if we needed one. Because we don't need one, even the term dismissal, I don't know if we even actually need to do that. It just doesn't, we just need to take no further action.
I'll suggest we move to dismiss this without prejudice, if that's all right.
All right, yep.
Okay. If there are no other questions from the board, I would entertain a motion.
I make a motion that we dismiss this request for agency action without prejudice.
I'll second the motion.
All those in favor say aye. 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 Let the record show that was unanimous. Thank you very much.
Thank you.
We are now moving on to docket number 2023-046, cause number 132-26, in the matter of request for agency action of Ovintiv USA for an order pooling interest, including the compulsory pooling of the interests of certain non-consenting owners in the 10 Tomlin wells identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all of sections 25 and 36, Township 2 South, Range 2 West. I will now ask for appearance of counsel.
Thank you, Chairman Borden, members of the board, Mitch Mayo of Lear & Lear, on behalf of the petitioner in this cause, Ovintiv USA, Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you very much. Over to you, Mr. Mayo.
Thank you, Mr. Chairman. Sorry about that delay. Mr. Chairman, members of the board, as mentioned, Mitch Mayo of Lear & Lear on behalf of the petitioner Ovintiv USA, Inc. With me today to testify in person is Mr. Peter Burns, senior land negotiator with Ovintiv, and testifying remotely from his offices in Texas is Mr. Christopher Wall. He is the senior reservoir engineer. Can we check and make sure he's on? I haven't seen him yet on the camera.
Yeah, we're bringing him up right now.
Oh, thank you. Can you hear me okay in there?
I can hear you, yes.
Perfect. Okay, you sound good here. Can I please have the witnesses sworn in at this time?
Please raise your right hands. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you for that. The resumes of each of these witnesses were submitted collectively as Exhibit A in this cause. If separately asked, each would verify their resumes as true and correct. Mr. Burns and Mr. Wall have each testified before this board on numerous occasions and been recognized as experts in their respective fields. Mr. Burns is an expert in petroleum land management, and Mr. Wall is an expert in petroleum engineering. Most recently, they were recognized as experts this past September in Cause 13221. Presuming the division has no objections, I would ask that the board again recognize Mr. Burns and Mr. Wool as experts in their respective disciplines for this cause.
Division, any concerns?
No objections by the division.
Thank you. They are so recognized. So.
Thank you. One other housekeeping item, I'd like to confirm that it's acceptable to move for admission of our exhibits at the end of our case in chief, if that's okay.
That'd be great.
Thank you. To summarize this case, as mentioned by the chairman in the introduction, this is a cause that involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production and comprised of the entirety of sections 25 and 36 in Township 2 South, 2 West in Duchesne County, Utah. Said drilling unit was established by board order on April 4th, 2017 in cause number 139-140 and as amended by the board order on February 7th, 2023 in cause 130-16. A true and correct copy of each of these orders was submitted as Petitioner's Exhibit B in this cause. In accordance with the 139-140 order and APDs approved by the division, Ovintiv drilled the Tomlin UT 7-1, 2-2, 36-25-1H well, which I'll call the Tomlin 1H well in this hearing, with a date of first production of June 11th, 2018. Subsequently, and in accordance with the 139-140 order as modified by the 130-16 order, and in accordance with the APDs approved by the division and the BIA, Ovintiv drilled and has begun producing from 9 additional Tomlin wells outlined in the request for agency action. As alleged in the request, and as will be established by Mr. Burns' testimony here today, there was only one known owner to this action who had not consented to participate and who was sent the requisite notice of opportunity to participate. That's Miss Judy Osler. Ms. Osler has, however, since receiving the REA in this cause, sold her mineral interest to Ovintiv, who has voluntarily pooled it in this unit, such that she is not being compulsory pooled here today. Although there are no known owners being pooled here today, some of the fee leases granted were granted by parties claiming by, through, or under the estates of certain deceased parties as identified in the request, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated are incomplete as to the proper distribution of the heirs or devisees. As such, there is a possibility of some unknown party claiming through these estates who is unleased and not pooled. And that's the purpose of this hearing here today. Consequently, as to such potential owners under these estates, Ovintiv, pursuant to the board's order entered October 13th, 2023, published the requisite notice of opportunity to participate in the Uinta Basin Standard for 2 consecutive weeks. Proof of this publication was submitted, identifying each of the estates and the parties claiming buy-through under them, was submitted as Petitioner's Exhibit N in this cause. No party has responded to that notice or otherwise tendered his or her shares of the costs for the wells. Oventive therefore seeks to have these parties be compulsory pooled and declared as non-consenting owners. As non-consenting owners, Oventive seeks the imposition of a 300% risk compensation award and the terms of a JOA materially the same as signed by the other working interest owners in the drilling unit, and which terms have been repeatedly deemed just and reasonable by this board in many compulsory pooling hearings. During the recoupment period, the unleased, because of the, let me back up, because of the difference in drilling dates between the Tomlin 1H well and the other 9 wells, there will be 2 acreage-weighted royalties to be applied in this instance, one that applies to the Tomlin 1H well and one that applies to the other 9 wells. During the recoupment period, with respect to the Tomlin 1H well, the non-consenting unleased owners will be entitled to a 19.1793% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the time of the Tomlin 1H spud, about March of 2018. With respect to the remaining 9 Tomlin wells, the unleased non-consenting owners will receive a slightly higher acreage-weighted royalty of 19.226243, again, which represents the fee royalty calculated as of the spud of the 9 wells in the spring of 2023. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations, Utah Administrative Code R 649-2-8A and -9A and B. As mentioned, a copy of the request was mailed certified to Ms. Judy Osler, the known party to be compulsory pooled, and was mailed regular mail to all other production interest owners within the drilling unit at their last address as disclosed by the relevant realty records, including to all relevant state, federal, and tribal agencies with jurisdiction within the drilling unit. Subject to receiving said mailing, as mentioned, Ms. Osler has sold her interest and will no longer be pooled. Oventive is formally requesting that she be removed from the request at this time. As mentioned, in addition to the notice of opportunity to participate that was published in the Uinta Basin Standard, notice of the filing of the RAA and this hearing was also duly published in the Salt Lake Tribune on November 12th, the Uinta Basin Standard on November 15th, and the Deseret News on November 17th. No objections or responses to the RAA were timely filed, but the division did file a notice of non-opposition. As none of the alleged remaining non-consenting parties timely filed a response to the RAA, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, we would move to enter an order of default against them.
I would ask the board for a motion in terms of the request for default. Isn't that correct? Will anybody make a motion to?
So moved.
Any silence?
And maybe to clarify that the hearing will proceed, you'll still make a determination. The default is kind of a legal decision that they have not appealed, they have not shown up, they have not exercised their rights, to clarify.
All those in favor say aye. Aye.
Thank you for that. With that in hand, Mr. Chairman, I'd like to move on to our first witness, Mr. Peter Burns. Mr. Burns, will you please state your name and spell your last name and state your business address for the record?
Sure. Peter Burns, that's B-U-R-N-S, and Oventive's address is 4 Waterway Square Place, Suite 100, in the Woodlands, Texas, 77380.
Okay. And will you please remind the board of your position with Oventive generally and as it relates to the lands at issue here?
Yes, I'm a senior land negotiator for Oventive's Uinta operations with responsibility over this drilling unit.
Okay. And one more housekeeping item. Can you just remind the board of Oventive's corporate and bonding status?
Yes. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of Oventive Production, Inc.
Okay. Now moving on to some exhibits. I'm going to do a couple of them here as a batch. I'm going to show you Exhibit C, D, which is 2 pages, and E. Do you recognize these exhibits?
Yes.
And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. With respect to Exhibit C, can you please help the board identify where the unit at issue is today in location to relevant landmarks?
Yes, so Exhibit C is a regional locator map showing the drilling unit at issue highlighted in red. This drilling unit is approximately 4 miles southwest of Roosevelt, intersecting with US 40 where it turns south towards Mighton.
Okay. And Exhibit D, as mentioned, it's 2 pages. One is a plat map and one is a table. Can you tell the board what this is and what this demonstrates about this unit?
Yeah, this just shows the different oil and gas mineral tracts within the DSU. There are 23 tracts within this DSU here. Tract 18 is tribally, or in this Exhibit D, the second page here is just a description, a legal description of each of those 23 tracts.
Okay. And Exhibit E.
Yeah, Exhibit E is a more simplified version showing the oil and gas ownership within those tracts. Tract 18 is tribally owned. Tract 1 is owned by the state of Utah. Tracts 6 through 8 are partially owned by the U.S. Department of Interior, BLM, and the remaining tracts are owned in fee.
Okay. Now moving on to Exhibit F. Do you also recognize this, and was this prepared? Well, do you recognize this exhibit?
Yes.
And was this prepared by you or someone under your direction or supervision?
Yes.
Okay. And tell the board what this is. In particular, could you help explain the compulsory pooled interest?
Sure. So Exhibit F is a DSU working interest ownership summary slide. Oventive is the majority lessee working interest owner in this DSU and is the operator of the 10 Tomlin wells at issue in this cause. The additional lessees, working interest owners in the DSU are Javelin Uinta LLC, Salt Creek Oil and Gas, Rig 2 LLC, Triple Sticks Drilling Ventures LLC, and Vaquero Partners 2 LLC. All have signed JOAs with Oventive, the terms of which contractually govern well elections, including the elections made on the Tomlin wells.
Okay. And have you, as operator, recorded a pooling declaration for the participating parties in this unit?
Yes, we have recorded a pooling declaration which pools the fee leases pursuant to the authorization contained in each of those leases, various pooling clauses.
Okay. And somewhat unique for the board is a pooling request where you're seeking to pool 0% of the interest. Can you explain to the board why that is?
Yes, so when we mailed out the RAA, originally we had the one owner, Miss Judy Osler, who was unleased. And, well, we mailed her a notice of opportunity to participate. And then we mailed the RAA, and she contacted us, and we were able to work out a purchase of her mineral interest. So that's why we've moved forward with the hearing here today, pooling 0% technically, but there are the unprobated estates that we are seeking to pool any unknown potential heirs.
Okay. Perfect. That's helpful. You mentioned Miss Osler, and I just want to clarify the timing. You discussed sending her a notice of opportunity to participate, an elect drilling unit?
Yes, we mailed her our standard notice of opportunity to participate proposal letter. She did not respond timely, so we filed the RAA, and upon receipt of the RAA is when she contacted us, and we were able to work out the purchase of her mineral interest.
Okay. The board, one point of clarification here, the board is used to seeing in these matters an election letter as one of the exhibits. This is the letter we sent to these parties. In this instance, that is not submitted because the only party to whom that applies is no longer being pooled. All of the parties subject to or claiming through the estates were provided published notice and not a notice. So just a point of clarification for the board if they have questions about that missing election letter. So there are no known owners being pooled here today. There are, though, estates. Can you talk to the board about the estates being pooled?
Yes, as Mr. Mayo mentioned, several lessors claim title in these lands through one or more of the estates of the following deceased record mineral interest owners: Alan Jeffrey Osler, John Anton Barbera, Ambrose Bruce Barbara, Angelina Regalia Barbara, Anton Barbara, Ardath Strong, Berta Vidier, Clista N. Foote, Darlene Oliphant, Dawn Strong, Edna M. Drollinger, Fred Allen Drollinger, Inez Lambert Poor, John Graydon Poor, Kay Brinkerhoff, Kai Myong Sally, Mary Agnes Patry Lambert, Orville Jeffrey Osler, Quentin Edward Sally, Shirley Jean Osler, Teresa Barbara Reagan Poor, Virginia Lambert, Wayne Stanley Osler. So either no Utah probate of these estates has been initiated, or if it was filed, they are incomplete, and that there's been no proper distribution made to the heirs or devisees of each.
Okay. And so you guys have, Ovintiv has done the title work, looked at the open interest, leased up everything they think is an owner. But this is out of an abundance of caution in case there's a distribution that differs from what Ovintiv's determined in its search.
Correct. Although, based on the affidavits of heirship and other inquiries and research done by Ovintiv and our lease broker, we believe that we have voluntarily pooled all the working interest owners, or Ovintiv or the other working interest owners have leased all of the successors. However, without an order from Utah court confirming their succession, the possibility that exists that unknown heirs may successfully establish succession. Such owners would be unleased, and therefore Ovintiv seeks to compulsory pool their interests.
Okay, and you heard me refer to Exhibit N, filed the affidavit of publication evidencing those. Can you confirm for the board that you received no responses, material responses from any of the parties claiming buy-through under the estates?
Correct. We received no responses to that.
Thank you. Now I'm going to skip, if I can, to the JOA. Do you recognize this?
Yes.
And is this an official business record of Ovintiv's?
Yes, it is.
Tell the board about this. Is this a standard form, one you use often in a lot of your developments?
Yes, this JOA form is a kind of a standard industry form supplied by the American Association of Professional Landmen, Form 610. This is the 1989 version that has modifications to address horizontal wells. This Exhibit L is materially the same form JOA that was sent with all notices that we mailed. The terms and conditions contained herein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including the JOAs signed by the other voluntarily pooled working interest owners in this DSU. Ovintiv has prepared identical terms for other drilling units. It has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
Okay. Thank you for that. So this is a standard form, one you're comfortable with, and one a lot of operators seem to be fairly comfortable with in your units.
Yes.
Referring to page 7 of the JOA, I just want to point out a couple provisions that we're all fairly familiar with. Can you identify for the board, although it's small print, what the non-consent or risk compensation awards are called for in the JOA?
Yes, so this page 7 of the JOA addresses the non-consent penalty, and in this particular one and most others that we deal with in the Uinta Basin, We have 100%, 300% non-consent penalty. These are the same terms assigned by the other non-operators within the same DSU.
Okay, so if Javelin, for example, when you mentioned was a consenting party in the 10 wells, if they elected not to participate in future developments, would they be charged a 300% non-consent or risk compensation?
Yes.
Okay, thank you. Let's go to Exhibit C of the JOA. Let me see. Can you tell the board what this is, kind of generally high level?
Yes, Exhibit C is the accounting COPUS procedures. This also is, again, in a standard industry form, almost universally utilized, similar to other JOAs within the Uinta Basin. This page C3, Article 3B sets the interest rate at the prime rate as published in the Wall Street Journal plus 3%, which has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses.
Okay. And overhead allowable to be charged. Can you talk about that?
Yes. Also within the COPUS, this is on page C9. This outlines the overhead charges, $10,900 for the drilling rate and $1,090 for the producing rate.
Okay. In your expert opinion, Mr. Burns, would you say the terms and conditions of this proposed joint operating agreement are fair and reasonable and consistent with those you see in the basin?
Yes.
Okay. Thank you. Moving on, if we can, I'd like to discuss the two kind of different batches of wells and the acreage weighted royalty that will apply to each. If I can show what we've submitted as Petitioners Exhibit G, the title is the Tomlin 1H weighted average royalty calculation. Can you tell the board what this is?
Yes, so this is Exhibit G is the weighted average royalty.
Well, actually, sorry, I got to step back. Do you recognize Exhibit G and Exhibit H?
Yes.
And were they prepared by you or under your direction or supervision?
Yes.
Okay, thank you. I apologize for cutting you off. Please tell the board what this Exhibit G demonstrates.
Exhibit G, this first portion is the average weighted royalty calculation for the Tomlin 1H, the original parent well. This shows the weighted average landowner's royalty for the sections 25 and 36 drilling unit at the time of spud of the Tomlin 1H well, which was the middle of March 2018, to be 19.1793%.
Okay. And Exhibit H, if you could tell the board what this is and where it will apply.
So this is similar calculation. However, this weighted average royalty applies to the 9 infill wells. So this landowner weighted average royalty as of spud of the first of the 9 new wells is 19.226243%.
Okay. Thank you for that. Before I move on, I'd like to refer back to the certificate of service on file and just have you confirm. Can you confirm that are you familiar with the certificate of service on file in this cause?
Yes.
And can you confirm that the persons identified on that are the persons either to be pooled, Ms. Judy Osler, or the production interest owners within the drilling unit?
Yes.
Okay. Can you also discuss where you got that information, preparation of a title opinion, internal records, et cetera?
Yes, those names shown are all of the production interest owners within the section 25 and 36 drilling unit. The addresses were derived from a title opinion effective February 15th, 2023, as updated by a search of the county records by our land broker Lone Wolf Energy, and as well as Oventive's internal land records.
Okay. Thank you very much. I think with that, I'm done with Mr. Burns and ready to move on to our next witness pending division or board cross-examination.
Division, any questions for this witness?
No questions for this witness.
Board, Mr. Moon.
So where you purchased Ms. Osler's interest, there's zero interest being compulsory pooled here. So you've basically accounted for all the interest. Does that also mean that there would be no, that all royalties would be paid out immediately? Anything in suspense?
Yes, I mean there are numerous title requirements here, so we are continuing to work through those to try to get as much out of suspense as possible. But the 9 new wells actually have not had their first payment yet. That's going out in January. So our division order group is working to set those 9 decks up this month, and then division orders will go out, and then we will continue to work through curative. There's, hundreds of title requirements in each of these title opinions, and this one's no different.
So at this point, do you know of any disputed mineral interests, or does everybody seem like they're happy with your conclusions?
I'm not aware of any disputes here.
Okay.
I mean, I guess that's for the title attorney's perspective. There's always disputes in ownership, and so it's when Mr. Burns mentions the requirements, the curative stuff. What he's talking about is obviously in title opinions. Someone calls ownership and says, Miss Garrison owns these 10 mineral acres, but Miss Garrison's neighbor claims to own them. So you might want to not pay her until they sort it out between the two of them. So as far as releasing suspense funds, just because everyone's accounted for and leased, certainly doesn't mean that the funds will be paid to them if there's a Utah attorney who says you might incur double payment if you do that. The law allows them to suspend.
Any other questions? Seeing none, back to you, Mr. Mayo.
Thank you. If it's okay, since Mr. Burns is the only witness, I'll just have him stay in a seat here, and we'll call Mr. Wall just in case there's follow-up questions for Land.
That's fine.
Thank you. Mr. Wall, are you still there, and can you hear me okay?
Yes, I can.
Okay. Did you hear Mr. Burns' testimony as well?
I did, yes.
Okay. To start off, please state your name and spell your last name if you could, and business address for the record.
Name is Christopher Wall. That's W-O-L-L. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
Okay. And remind the board your current position with Ovintiv generally and as it relates to these lands today.
I'm a senior reservoir engineer working the Uinta asset for Ovintiv.
Okay. And in that position, I'm assuming you have familiarity with the lands here discussing sections 25 and 36, 2 south, 2 west?
Yes.
Okay. Thank you. I'm going to show you what has been submitted as Petitioners Exhibit K. This is a 2-page exhibit. Do you recognize this exhibit, Mr. Wall?
Yes.
And was this prepared by you or under your direction or supervision?
Yes.
Okay. Can you please tell the board what these 2 pages of Exhibit K demonstrate relevant to today's hearing?
Yes. The first slide is the general location of the Tomlin 1H well along the east half of the drilling unit. And this shows the well and the well control around it at the time of drilling, which was March 15th, 2018. And the well was completed as a producing oil well with the productive intervals within the U.S.M Butte member of the spaced Lower Green River Wasatch Formation. The date of first production of June 11th, 2018.
Okay. And
the second slide is the Yes, the second slide is the general location of the 9 additional Tomlin wells that were drilled between March 28th and June 28th, 2023. These wells are producing within the intervals of the U.S.M Butte, Castle Peak, and Upper Wasatch formations of the spaced Lower Green River Wasatch Formation. The date of first production was August 23rd and September 5th of 2023.
Okay. And so you mentioned with the first page, the Tomlin, that you had limited well control, but you also mentioned that you targeted the U.S.M Butte. Is the U.S.M Butte considered to be a kind of a prolific bench within the basin? Is it a safe target, a risky target? Can you talk through the U.S.M Butte versus other members?
Sure. The U.S.M Butte is what we consider a primary target. It is the most prolific of the targets that we do drill.
Okay.
However, each of the formations have unique drilling risks. The U.S.M Butte specifically does have clay intervals that you can encounter as you drill along the interval. As you drill Upper Wasatch wells, you have to drill through the U.S.M Butte, and you could encounter those clay intervals as well. And I would say that even though you have increased well control or a number of wells that are drilled around you, doesn't eliminate risk as you're drilling, as these clay intervals can move around. Also, when you're drilling next to wells that have already been drilled and have been producing, you can encounter depletion, which does increase your risk while drilling.
Okay, so it's fair to say that the Tomlin 1H maybe had increased risk because of lack of well control, whereas the other 9 wells may have had increased risk due to the fact that there were different geologic and interference issues potentially with existing wells and production. Is that a fair statement?
That is a fair statement.
Okay. Let's move on to Exhibit I. And this is several pages. Do you recognize, we're going to talk about Exhibit I and Exhibit J. Do you recognize these exhibits?
I do.
And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. Can you tell the board what these exhibits demonstrate?
These exhibits are the summary of all the actual costs incurred in drilling, completing, and operating costs for the wells, the Tomlin 1H, and then also the subsequent 9 wells.
Okay. And so each one of these is for one of the Tomlin wells at issue here today. Exhibit J is a summary of those well costs.
Yes.
Okay. So can you tell the board what the total capital expenditure was up front, essentially, for the development of these 10 wells?
It was the total development cost was roughly $100 million.
Okay. And Ovintiv, if I remember from one of the prior slides, is about a 95% working interest owner in this unit. It's fair to assume that Ovintiv bears the burden of paying 95 of those $100 million.
That's correct.
Okay. Let me, how close were these costs to AFE costs, and were they within a reasonable variance in your opinion?
Yes, all the wells were, the cost for all the wells came in within a reasonable variance to the original AFEs.
Okay. In your expert opinion, were these the costs incurred to drill each of these wells fair and reasonable and justified?
Yes.
Okay. Remind the board, if you could, there's no exhibit about this. What is Ovintiv's plugging and abandonment costs estimate?
Yeah, the P&A estimate is $75,000 per well. And this is a figure that's consistent within the Uinta Basin P&A costs charged to and by Ovintiv.
Okay, and that's based on 100%?
Yes, it's based on 100% working interest ownership.
Okay, thank you for that. Finally, last slide. I'd like to talk a little more about the risk. We hit on it a little bit when we talked about the different kind of depictions of the wells. Talk through some of the risks generally that you see in development, some of the risk incurred in this development, and kind of what Ovintiv sees as the risk in a development such as this.
Okay. So the Tomlin DSU is the deepest, highest pressure, highest temperature environment that Ovintiv has drilled in the basin. And when you enter into an environment like this, you increase the risk of safely and efficiently drilling the wells, which leads to really less certainty on your capital expenditures. There's also some shallow drilling hazards with artesianal water flows that can be encountered, as well as the U.S.M Butte specifically has these high clay intervals with a potential to collapse and stick drill pipe and casing. And then these intervals also affect upper Wasatch wells, as you have to cross these intervals to get to your target. And, you know, specific to the development of the Tomlin DSU, we did encounter 3 situations. One, we had cement flash set with inside of our casing, which led to some costly remediation and ultimately the loss of approximately half the lateral, which is a loss of value and incurred additional capital costs. We also had a shallow surface flow, which led to us re-drilling the surface hole for one of our wells. And in addition, on the 1H, we did encounter some of this high clay causing a sidetrack and ultimately sticking the casing. So we also ended up with a short lateral here. So 2 of the 10 wells in the DSU did not get to their intended lateral length.
Okay.
And on top of all of that, I mean, if we look at this large development, you know, this DSU is a $100 million investment, and these investments have a 3 or more year payout. So future oil prices can really impact the results of this investment. Yet these large investments, you know, and developments are really good at preventing waste. However, tying up a significant amount of capital and compounding operational risks such could lead to massive delays, which puts a pressure on our entire year program. So, you know, the price uncertainty, the price volatility also place really significant risks on the company's performance, and also risks the full year performance for Ovintiv throughout the year. So, you know, when we look at all the risks, you know, developing oil and gas mineral, it always involves significant risk. And, you know, therefore, you know, I feel the 300% risk assessment award is justified.
Okay. Thank you. It sounds like this was a pretty significant portion. You know, $100 million development is probably a pretty significant portion of Ovintiv's portfolio this year of work in the Uinta Basin.
Yeah, this particular development was about 1/3 of our budget for this year in the Uinta asset.
Okay. So if something does happen here, there is significant risk, at least from Ovintiv's perspective.
Yeah, that's right. Not only, you know, from a business performance, but also, you know, this one large project, any delay here delays our entire year. So these large investments come with a larger amount of risk.
Okay. Well, I appreciate that. Follow-up question, and I believe you've answered it sufficiently, but in your expert opinion, is a 300% risk compensation award justified with respect to each of the Tomlin wells?
Yes.
Okay. Thank you. With that, I have nothing else for Mr. Wall, subject to cross or questions from the board.
Division.
Thank you. Peter Pankey with the division does have one question that he would like to ask.
Yeah, Peter Pankey with the division. Mr. Wool, in exhibit, you just talked about this re-drilling of the surface hole, and this is just a curiosity. I'm curious as to how often that happens in when you're setting surface, if you have this problem frequently.
I don't know the actual incident rate. I'm trying to think. In this past year, I know we've encountered it at least twice on different pads. And you can see this well was drilled in March March 28th, 2023. So that's the springtime, and there was a pretty record snowfall this past year. So that's probably exacerbated these issues, but we have seen this in the past and have seen it subsequent to these wells.
Okay, and so do you think that that's a freshwater issue, or are you guys near an injection well that might create a similar problem?
Oh no, this is very close to the surface, so this isn't injection. This is surface water.
Okay, perfect. Thank you.
Thank you. And with that, the division has no further questions.
Thank you. Board, any questions for this witness?
Yeah,
Yes.
go ahead, Steve.
Oh, Mr. Yeah, go ahead.
Whichever.
Mr. Chair.
Mr. Wall, were the laterals on all of these wells intended to be approximately the same length?
Yes.
And was that the case? All of the wells were able to be drilled to that entire length? Is that correct?
Yes, all the wells we were able to drill them to their respective lengths. However, with the Tomlin 1H, the casing got stuck on the way down and we weren't able to get the casing to TD. So we're not able to effectively stimulate and complete the entire lateral. In the case of the well that we had flash cement set in that, casing got to bottom. However, we were unable to remediate that to our satisfaction to TD. So when something like that happens, we end up without cement behind our pipe, which is not fun. It's risky, especially when we want to protect any contamination of fresh water. So the remediation there did not go 100% to plan. So we ended up only with half a lateral to ensure that we were protective of freshwater zones above us.
Okay, thank you.
Any other questions?
Yeah, thank you, Mr. Wall. Can we go back to Exhibit K, the second page? When I look at that, and we talked about 9 additional Tomlin wells, and I can only see 7 in sections 36 and 25. Can you explain to me why that's all I can see?
There are stacked laterals. So the Upper Castle Peaks wells, they are pink, a pinkish color. They're right underneath the blue.
Got them. Okay, got them. Thank you. All right. And then you talked about the pressures and temperatures. So what was the true vertical depth that you were working with here, and what was the pressure and temperature that you encountered?
Trying to remember the reservoir pressure, or the pressure that we encountered, was in excess of 3,000 psi. This is an area of abnormal pressure, high pressure. The temperature, I'm sorry, I don't know.
Any other questions? Yes.
So you mentioned that 2 of the laterals you weren't able to complete. Any thoughts on in the future being able to recover reserves from that, perhaps extending another horizontal from another drilling unit, or any thoughts on that? 'Cause it's too bad that all of those 2 laterals, how was about half of each of those 2 laterals was not completed, and then just thoughts on future.
Yeah, so the Tomlin 1H is roughly a little less than 2,000 feet short. The one of the Castle Peak wells, it's the 46H, is actually roughly 5,000 feet short. There is a potential for coming back and drilling a short lateral from the north side of the DSU. However, what we did try and do is we pumped a larger job, larger completion on the first half of the lateral, the closest to the north side on the adjacent Upper Castle Peak, to try and capture some additional resource there. And then went to our normal job size on the heel section of the lateral. So we did make an attempt to try and capture some additional reserves or resource in that untapped resource there on the northwest side of the DSU.
And on the one that the casing made it all the way, but the cement did not. You mentioned protecting fresh water. So there's still a concern to protect fresh water when you're down there 7,000-8,000 feet.
Yeah, well, our practice is to try and have at least 2 barriers. And so in this particular case, we have a long string that goes across the entirety of the lateral, and we try and bring cement back to surface on that one. And then in between that and the actual freshwater formations, we have another string of pipe that is cemented to surface. And so when you don't have cement across your lateral, it also increases the risk of having a poor completion. But it does come with a risk that, if something were to happen to your intermediate string of pipe, that you could enter a situation where you have, produced fluids entering a freshwater zone. But this is why, the board, or Division of Oil and Gas, has set the rules and regulations on how to set pipe. They review our wellbore designs, et cetera, to make sure that we are adequately and safely protecting any freshwater zones. But it's also Oventive's policy is to try and go above and beyond that and attempt to do a little bit more. And in this case, what we try and do, in this particular case, what we did is we actually squeezed cement from as far down as we could and brought that to surface. So in this particular well, we do not feel that we are endangering freshwater zones, but it was a risk that we encountered as we try to remediate the wellbore. If we were not able to bring cement up, we had discussions about just completely abandoning this well because of the risk to freshwater zones.
Thank you.
Yes.
So, Mr. Wall, on two of the wells, you say that they were stacked laterals in this pooling unit. Were there enough encouragement that you would go back and develop the additional zone where the other wells were drilled that were only that were not stacked in different reservoirs?
Yeah. So the way to think about this is there are, if we're targeting three different formations, you have the Upper Castle Peak at the top, and about 200, 150, 200 feet below that, you have the U.S.M Butte. And then below that, you have the Upper Wasatch, if you think about the Upper Castle Peak to the Upper Wasatch can be 400 feet apart. So we tend to put an Upper Wasatch well directly below an Upper Castle Peak well, and then 660 feet to the east or west of those two laterals, we'll put a U.S.M Butte. So we are stacking completely throughout the reservoir. We just have learned that you don't want to stack all three wells on top of each other because they will directly communicate. Does that make sense?
Yes. So you have no further plans for more development then in this pooled area, is that correct?
That is correct.
Thank you.
Any other questions?
Yeah, I don't want to hold things up here, but I am interested in seeing what those TVDs and pressures and temperatures that you encountered were in the different horizons. So if you could get that back to me sometime. It doesn't have to be today. Thanks.
Mr. Moon.
Questions bring up more questions. So there is more opportunity in this drilling unit, correct? Because how many U.S.M Butte wells did you actually drill here out of the 9 or 10? Just 3 or 4?
We have 4.
4
U.S.M Buttes and 3 in the other zones.
But isn't there additional opportunity in each of these for, in the future, up to 8 wells?
Yeah, that's correct. One of the areas that we look for is actually on either side along the section line of the DSU. So in this particular case, we have XCL as the offset operator, so we'd have to work with them on how to develop that. But that would be one of the areas that we're interested in to develop. So it's, developing the lands in between these two DSUs on either side.
But in the main part of the drilling unit, it is basically drilled up then. You're comfortable with it just seems like there should be room for 8, not 4 wells in that highest, most prolific zone.
Right. So we are, continuing to study and trying to determine how many wells effectively drain each of the formations. In this particular case, we're testing a 4-well development. Some of our neighbors have done 5 in that Elam Butte interval. So we're, we watch that and we try and determine, what is the most capitally and efficient way to drain the resource. So we'll continue to study that. It is potentially, you are onto something, that there is potential to come back and develop additional wells in this particular DSU. But as of this time, Ovintiv does not have plans to do so.
Any other questions? Seeing none, back to you, Mr. Mayo.
Thank you for that and the good questions and discussion. Mr. Chairman, I'd like to, before I move on, I guess it's probably appropriate to move for admission of exhibits at this point in time. Exhibits A through N, petitioners' exhibits.
They are so entered.
Okay, thank you for that. And with that, I'll turn my time to the division for their case in chief.
Division, over to you.
Thank you. As we have reviewed the request and the associated exhibits, and based on the testimony and the questions being asked here today, the division has no opposition to this request. So.
Board, any questions for the division, or does that statement satisfy? Huh? Okay. In that case, back to you, Mr. Mayo. Huh?
Yeah, briefly, I'd just like to offer to the board that all the statutory and regulatory requirements have been met here today. Ms. Ostler, the only known party with an unleased interest in this unit, has since sold her interest and will not be compulsory pooled regardless of the decision the board makes today. The remaining parties are all potential heirs claiming by, through, or under estates. And as mentioned, the regulatory requirements have been met to pool them. And with that, I'd ask that the board enter the pooling as requested, minus Ms. Ostler. And I'd like to thank the board for their time and attention. And on that, I'd submit.
Thank you. Division, any last statements?
None.
Thank you. Do we need to retire for consultation, or are we prepared for a motion? I would then entertain a motion.
Mr. Chair, I move that we accept this RAA as requested.
I'll second that.
Any last comments from the board? Seeing none, all those in favor say aye. Aye. Let the record show that was unanimous. Mr. Mayo, can you please prepare the necessary documentation?
I'm happy to. Thank you, Mr. Chairman.
Thank you. And that brings us to docket number 2023-047, cause number 130-25. And I believe this matter has been continued to January 2024. So we can proceed to item number 4 on the agenda, which is docket number 2023-048, cause number 600-05. The matter of the request for agency action of Ovintiv USA, Inc. for an Order 1, modifying and/or extending the board's order entered in cause numbers 139-134, 139-150, 600-02, and 600-03, and 130-14 to orders to previously unspaced lands, and B, reducing the north-south drilling unit boundary setbacks from 330 to 100 feet with certain exceptions, and 2, establishing special drilling units for drilling unit boundary wells, all for the production of oil and gas and associated hydrocarbons from the lower Green River Wasatch formations. I will now ask for appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of Petitioner Ovintiv USA, Inc. Mr. Chairman, if we could break for maybe about 5 minutes so I can get the computer set up and all of that.
Oh, not a problem at all. Thank you. And why don't you just appear yourself
ahead.
for us? And
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay, now we'll take a brief break. So over to you, Mr. McDonald.
Thank you, Mr. Chairman. With me today, testifying on behalf of the petitioner, Mr. Jordan Lair, who's the senior land negotiator, excuse me, and appearing virtually thanks to the board's order that was entered on December 1st, are Mr. George Jennings, who's the geologist, and Mr. Christopher Wall, who you've had in the previous matter, who's the senior reservoir engineer. I don't know if the technical team can call them up.
We
on
are
our screens.
pulling
Okay.
them up as we speak.
Thank you. And I would ask that the witnesses be sworn in at this time.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Did you get that from everybody? George, do you want to say that again, please?
I do.
Okay, thank you. Members of the board, the resumes of all three witnesses were submitted as collectively as Exhibit A in this matter. If each were separately asked, they would verify that the contents of their resumes are true and correct. Mr. Lair will be a fact witness only, and Mr. Jennings and Mr. Wall have previously been recognized by the board as experts in geology and petroleum engineering, reservoir engineering, respectively. Based on the resumes and the board's previous recognition of their expertise, and presuming the division has no objection, we would ask that they again be recognized as experts in those fields for purposes of this cause.
Division?
No objections by the division.
Board, any concerns? Seeing none, they are so recognized.
Thank you. And then, as always, we want to confirm that it's acceptable to move for admission of our exhibits at the end of our presentation of Chief.
Perfect, thank you.
Thank you. Members of the board, today is Ovintiv is before you seeking approval of a three-part request. First, Ovintiv seeks to modify certain existing two-sectional Lower Green River Wasatch stand-up drilling units to add partial sections along the Uinta Special Meridian line boundary that would otherwise not be individually developed. For the same reason, Ovintiv seeks to create new drilling units inclusive of partial sections, the lands for which have not yet been spaced. These are the 6 drilling units identified in page 2 of the request for agency action and are labeled as new DSUs therein. This is to be accomplished through the modification and/or extension of existing board orders as outlined in the request for agency action. If granted, OVINIV seeks to develop these 6 revised or new drilling units through long lateral horizontal wells in excess of 2 miles in length. Similar to previous board orders relating to OVINIV-operated drilling units, OVINIV does not seek overlapping drilling units for vertical, short lateral, and long lateral horizontal wells. Instead, OVINIV is requesting that production from any existing vertical, directionally drilled, or short lateral horizontal well remain on a wellbore or a sectional drilling unit basis until the first long lateral horizontal well is drilled on the modified or newly established drilling unit. And then effective as of the date of the first month following the date of first production, providing for production that all the wells be allocated on the requested new drilling unit basis. As the board is aware, this is commonly referred to as conversion. This prevents premature and unnecessary modification of existing rights to production, and until such time of the drilling of the first long lateral horizontal well on the requested drilling unit occurs and mandates such modification. As has been done in previous OVINIV spacing matters, OVINIV requests the board to take administrative notice of the testimony of Mr. Mike Jensen and the exhibits that were admitted into evidence in the 139-134 hearing pertaining to the concept of drilling unit conversion and how correlative rights to existing wells remain protected thereby, pursuant to Utah Code Annotated Section 63G-4-206 1B subsection 4. Will the board accept that administrative notice?
Yes, it is accepted.
Thank you. The second part of the request, OVINIV seeks uniform reduction of the heel toll, or because these are stand-up units, the north-south drilling unit setbacks from 330 feet to 100 feet generally, or 200 feet as to these drilling units with the southern boundary along the U.S. Special Meridian. And there will be testimony as to why that's the case. As the testimony will reflect, such reduction not only results in additional resource recovery that otherwise would be left in the ground, but also does not adversely affect the correlative rights of the production interest owners in the adjacent drilling units for at least 10 years and then only minimally, if at all. As the board is aware, it has previously granted such relief in other areas of the basin, and this is the trend requested by nearly all of the operators therein with respect to long lateral horizontal well development, as evidenced, excuse me. Finally, OVINIV is seeking establishment of numerous internal and external drilling unit boundary drilling units, as outlined in the request for agency action, with authorization to drill up to 5 wells, with the setbacks, heel toe setbacks, and up to 330 feet flexibility along the boundary line between the 2 existing drilling units, and with the same caveats that the board has previously granted before. This, too, is similar to relief that the board has previously granted on several occasions, and I think the board understands the need for these drilling unit boundary wells. True and correct copies of the relevant board orders relating to the requested relief were collectively submitted as Exhibit B in this cause. Since there's Indian mineral lands involved in most of the drilling units, communization agreements are required, and the agencies, whether under federal guidelines or by practice, require a spacing order of the board for such communization agreements to be approved. This is another reason why OVINIV is before you today. The board has jurisdiction over this matter pursuant to Utah Code Annotated Sections 40-6-5, subsection 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested drilling units, to the working interest owners, including the unleased owners and the established drilling units adjacent to the affected areas due to the requested setbacks, and to the Bureau of Indian Affairs and the Bureau of Land Management, being the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings, which numbered in the many thousands, were sent to these parties at their last addresses disclosed by the relevant agency and county realty records. The record will also reflect that notice was duly published in the Salt Lake Tribune on November 12th, in the Uinta Basin Standard and the Vernal Express on November 15th, and the Deseret News on November 17th. The division filed a response on November 22nd expressing non-opposition, presuming OVINIV meets its burden of proof at hearing, as today's testimony will reflect these conditions have been met. No other objections or responses were received. And with that, I'll commence my examination, Mr. Lair. Mr. Lair, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, L-E-H-R. Business address for Oventive is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380. And I'm currently a senior land negotiator with Oventive with responsibilities over the area subject to this request.
And for the record, would you please state Oventive's business, corporate and business bonding status, please?
Sure. Oventive is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal, Indian, and state agencies. It is the successor by name change to Newfield Production Company and merger of Oventive Production Incorporated.
All right, Mr. Lear, I'm going to direct your attention to what have been marked as Exhibits C through I. They're being shown on the screen. Excuse me, I went one too fast. Do you recognize these exhibits?
I do.
Then were they prepared by you or Oventive personnel with your review and input?
Yes, they were.
Okay, turning your attention to Exhibit C, which is shown on the PowerPoint presentation, please explain to the board what this shows.
Sure. This is just the regional locator plat showing all of the affected lands in red. And it's also showing that, our Mighton and Central Basin Prospect area extends from Arcadia to Randolette / Leland Bench. So showing the regional extent of the lands that are part of this request.
And that's the Mighton town site right in the middle, is that correct?
That's correct.
All right. Now turning your attention to Exhibit D, would you please explain to the board what this shows and its relevance to today's hearing?
Yes, so as Mr. McDonald mentioned in the opening, this is what is referred to as the new DSUs that we're seeking to establish. So this is showing all of the existing wells, including 3 long lateral horizontal wells, where conversion has occurred on previously established 2-section DSUs, and where Oventive now seeks to include the irregular sections along the meridian boundary for development with 15K laterals.
All right, and just on those ones that already have the existing long lateral horizontal wells, is it your intention that they stay on that basis until you drill the new 15K laterals and then they'll convert?
Correct. So conversion will only occur when a subsequent longer lateral is drilled in the DSUs that we're requesting.
Okay, now turning your attention to Exhibit E, would you please explain to the board what this shows and its significance to today's hearing?
Sure. So the exhibit in front of us kind of shows in black the RAA area, so all of the lands that are subject to the request, and then in blue, we are showing where the DSUs that are established that we're seeking reduced setbacks. As Mr. McDonald referenced in the opening, we're seeking 100-foot setbacks on the north-south.
Significance to today's hearing.
Sure. So Exhibit F is just the plat of the internal drilling unit boundary wells, or DSUs, that we're requesting. One thing to note for the board is all of the drilling unit boundary well DSUs that we're requesting, both units that are going to comprise them are currently operated by Oventive, and Oventive is the majority working interest owner across all the lands in the RAA.
Now turning your attention to Exhibit G, again, would you please explain what this shows and its significance to today's hearing?
Sure. So this is similar plat showing the external drilling unit boundary well DSUs that we're seeking to establish.
And same thing, that Oventive is the operator and the majority working interest owner in all of these as well?
That's correct.
Now turning your attention to Exhibit H, which is a 3-page exhibit. Starting with page Exhibit H1, would you please explain to the board what this shows?
Sure. So Exhibit H1 is showing in red, the RAA lands, and then we've kind of color-coded the various orders that pertain to the lands within the RAA. And as you can see, kind of in the bottom right-hand corner, that area is currently unspaced, and that's corresponding to the new DSUs that we're seeking to establish.
And again, many of these orders were supplied as part of Exhibit B, if you care to get into it. Turning now to page...
Board within the context of the RAA lands where there's already exist lands kind of out to the eastern portion of it.
And finally, H3, please explain what this shows.
So this is showing the current drilling unit boundary well DSU spacing within the RA lands and adjacent there too.
All right, and as these exhibits kind of show, it's kind of been a piecemeal thing so far, so the intent by this request is kind of to make a uniform approach to development of the Miton and Central Basin area. Is that correct?
Yeah, that's correct. So as you could see with the first H1 slide, there's been a number of various orders within the broader RAA lands here, and we're effectively just seeking to standardize across that whole RAA area.
All right, in all of these, in this area, are there Indian minerals, whether allotted or tribal, in portions of many of them?
That's correct. There are Indian minerals in most of these DSUs inside of the RAA area.
And what has been your experience and the company's experience with respect to the federal agencies on how to deal with those mineral interests in these drilling units that you request?
Yeah, and so in Oventive and my personal experience, when Indian minerals are involved, a spacing order not only facilitates but is required for the BLM and or the BIA approval of a conforming communitization agreement, whether by guidelines or actual agency practice.
Okay, now turning your attention to what has been marked as Exhibit I, would you please explain to the board what this represents?
Sure, so Exhibit I is just us showing in the plat here the various parties that were noticed. So within the red hatched area being the RAA lands, all production interest owners were notified. And then outside of those lands where you're seeing the pink notice area, all working interest owners, including unleased owners in the established drilling units adjacent to the DSUs at issue, were notified due to requested setbacks.
All right, I'm going to now refer you to the Certificate of Service and the Supplemental Certificate of Services, which is about the size of the Manhattan Yellow Pages. These are pleadings that were submitted to and on file in this cause that were prepared by my law office. Do you see all these names and addresses that were part of this?
I do.
And who are those parties and how were their names and addresses derived?
So those are the parties that I just referenced, being the production interest owners within the RAA lands or working interest or unleased owners in the adjacent lands. And they were derived from our own internal records as well as the BIA records and the county records. So we spent the better part of a year compiling this notice list.
All right, now I'll represent to the board that we did mail out to all the parties that are listed on that. And there were several that were returned. And to the extent that we were able to determine more current addresses by forwarding things like that, we also moved it. That's why there's 6 supplemental certificates of service. With that, that concludes my examination, Mr. Lair.
Division, any questions for this witness?
I just have a couple questions. If we could go back to Exhibit C. Oh, I'm sorry. It's D. So, Mr. Lear, there are numerous wells indicated there on top of the laterals. Is Oventive the operator in all of those wells that you're aware?
Yes, I believe we are the operator of all the vertical wells shown there.
Okay. And just for clarification, Exhibits F and G, when we're talking about the new spacing units, you indicated that you're the majority, Oventive is the majority worker interest owner.
That's correct.
Do you have, I mean, just because there was nothing indicated in our information, I mean, are we talking 51%, 90%? What's kind of ballpark in the area?
Yeah, across the RAA area, it's going to vary, but in a general sense, we're easily in excess of 80% working interest in each and every one of these.
Okay. And lastly, as we indicated, all the notices went out. I'm assuming there was numerous returns of not being able to know the address or not being able to find. Are you aware of any returns that were working interest owners that in the units?
I'm not.
Okay. All right, no further questions.
Board, any questions for this witness? Mr. Moon.
So what determined not going further west with this? Oventive has a lot of lands to the west. Was that because you started to go into laydowns and didn't want to mix the two, or?
Yeah, you're you're dead on, Mr. Moon. So the intention of this request is to space uniformly the entire area that Oventive believes is best developed via stand-up orientation, and Mr. Jennings will kind of talk through that a little bit, but that's why this request is sort of limited to these lands, is it's where we've clearly identified that stand-up development is appropriate.
I just have a question on some of these exhibits, because there are different lands outlined on different exhibits for various reasons. The one I'm looking at is the Exhibit E, the reduced setbacks. Part of the lands are blue, part are not. So will the entire area have this reduced setback when you're done? Are you trying to make everything within your requested lands the same, even though some things are?
Correct, where we can support it. And so I think this slide is best looked at with the spacing slide that shows the existing 100-foot setbacks, because most of the white area on the prior slide is where we've already got 100-foot setbacks through prior orders.
Okay, I just want to make sure that when you're done, everything in the requested lands will be uniform. Is that your intent?
Correct, with the exception of where we've drawn that red box.
Okay, thank you.
Mm-hmm.
Any other questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. At this time, I'll commence my examination of Mr. Jennings. Again, if the IT people could bring up Mr. Jennings on the screen. Great. Mr. Jennings, would you please state your name and business address for the record?
Yes, my name is George Jennings. That's Jennings. And I work at Oventive, and I'm located at 4 Waterway Square Place, Woodlands, Texas, 77380.
And you're the geologist that's working this area, Central Basin and Mighton area?
That is correct.
All right, I'm going to show you what have been marked as Exhibits J. Do you see the screen okay, or do you have these exhibits in front of you?
Yes, I do.
Okay, so Exhibits J through M. Do you recognize these exhibits?
Yes, sir.
And they were prepared by you or Oventive personnel with your review and input?
That's correct.
Okay, please, directing your attention to Exhibit J, would you please explain to the board what this shows and its significance to today's hearing?
Sure. This is the stratigraphic definition for the lower Green River to Wasatch transitional formations. And it comes from, this is something that we've shown many times to the board. And I'm showing on here the type log location relative to the lands in question today.
Now turning your attention to Exhibit K, please explain what this shows.
Sure. This is a look at the type log that's a little bit closer in the center of the lands in question. And so it's a correlative type log of the primary targeted intervals that we're planning on developing.
All right, and turning now to Exhibit L, please explain what this shows and its significance to
area. And it highlights that the lower Green River Wasatch transitional formations constitute one common source of supply in this area. And yeah, that's pretty much what I'm showing here.
And this uniformity also is conducive to long lateral horizontal development, is that correct?
That's correct.
All right, now turning your attention to Exhibit M. Please explain the significance of this exhibit and its relevance to today's hearing as well.
Yes, this is a map showing the areas that we're addressing, as well as showing the wells with observed stress indicators, and all, which are the blue circles with the arrows indicating the primary stress direction there. And also on here, I've highlighted 2 wells, which are the PVT data, which we used for the drainage calculations, which Chris will talk about a little bit later. We have an average fracture orientation of north 69 west in this area, in this red highlighted area here, which supports a standing, a stand-up.
Supports a stand-up drilling unit orientation?
Yes.
And finally, is it your expert opinion that the Lower Green River Wasatch formations constitute one common source of supply?
Yes, it is.
Mr. Chairman, that concludes my examination of Mr. Jennings.
Division, any questions for this witness?
The division has no questions for this witness.
Yes, Ward, any questions? And lead off, Mr. Church.
Yes, I have a question on Exhibit K. I believe that's the exhibit, where you show the intended well paths down on the southeast part of the RAA. You show well lengths to cover 2 vertical wells, 2 sections. I know you're requesting lateral lengths of in excess of 2 miles. I'm wondering why the partial section in this very southeast corner of the survey is not going to be drilled with those laterals, when on other maps it shows that it's part of the pooled area with the 2 sections above it.
You're referring to the southeast corner, just west of the 4 South 1 East label on this.
That's correct.
I believe that Jordan might be able to speak better to this than what I can, but I believe that these are currently only spaced as a 2-mile DSU, and part of the application that we're trying to accomplish here is to include the correction sections there as part of those units.
That's correct. So essentially on the prior exhibit, we were showing the existing wells, and on Exhibit D here, we are showing the new units we would like to establish. And so the existing wells being the Ute Tribal 14-8, 4-1-17-20 7H, and for abbreviation, the other Ute Tribal 1HR there. I believe those are the wells that you were referring to on the prior exhibit, and yes, they are currently drilled and spaced for 2-section development. So what we're seeking to do is come in now and include the irregular sections to the south, such that we could drill longer laterals to develop them. Otherwise, we feel it'd be challenging to ever have a horizontal well drilled there.
That was my question. I was not very clear in asking it. So future wells are intended to include that, essentially other half section.
Correct. And as we discussed, or as I said in my prior testimony, we're going to leave the wells that are currently there producing on a 2-section basis until subsequent longer laterals are drilled. So there'll be no change in the payment of those wells until we actually drill longer laterals in here.
Okay, thank you very much.
Any other questions from the board? Seeing none, back to you, Mr. McDonald.
All right, with that, I'll commence my examination. Mr. Wall, again, if the IT people could have Mr. Wall back up on the screen. Thank you. Mr. Wall, would you please again state your name and address, business address for the record?
Name is Christopher Wall, W-O-L-L. Business address 4 Waterway Square Place Drive, The Woodlands, Texas, 77380. And I'm a senior reservoir engineer working the Uinta asset for Ovintiv.
All right, I'm going to direct your attention to what have been marked as exhibits N through Q. Do you have those on your screen or in front of you?
Yes.
All right. Again, do you recognize these exhibits?
Yes.
Okay, and these were prepared by you or Ovina personnel with your review and input?
Yes.
Okay, turning your attention to Exhibit N, this is a 3-page exhibit starting with page N1. Would you please explain to the board what this shows and its significance to today's hearing?
Yes, these illustrations reflect the setbacks that we are requesting with this administration approval. It also shows the orientation of the maximum stress direction. It's 69 degrees north and west. Effective half fracture lengths of no more than 110 feet in the Uteland Butte. And it's our opinion that requested setbacks will prevent waste and maximize natural resource recovery, and correlative rights are not adversely affected.
And you'll address the drainage radius in a subsequent exhibit, is that correct?
That is correct.
All right, turning your attention now to page 2 of Exhibit N. Again, explain what this shows.
Again, this is a illustration of the setbacks requested. And in this particular demonstration, we are showing the 100-foot setbacks on the north side and the 200-foot setbacks requested on the south side. We're requesting the 200-foot on the south side due to the irregular section line there, as its angle would potentially intersect the half fracture length if we were to get closer than 200 feet.
And finally, turning your attention now to page 3 of Exhibit N, please explain what this shows.
This is similar to the previous slide where we're showing the stress orientation and the 100-foot setbacks from the north, and again 200-foot setbacks on the south side due to the irregular direction of the section line on the south side.
And this also shows the 560-foot setbacks from the east-west boundary lines, is that right?
That is correct.
And that's going to stay the same under this request. It's just the north-south setbacks that are being asked for reduction.
That's correct.
All right. Now turning your attention to what has been marked as Exhibit O, would you please explain to the board what this shows?
Exhibit O is the drainage calculations based on Hills and Evers. What we also are showing 2 different PVT analysis used that were on a previous exhibit from Mr. Jennings. What we're showing here is that at 5 years, there is no drainage of adjacent lands.
All right, and again, the board, the Hill and Evers methodology has previously been accepted by the board and the division in these other matters for these setback reductions. Okay, now turning your attention to what has been marked as Exhibit P, would you please explain the significance of this?
So Exhibit P, it's intended to justify the new DSUs along the U.S.M boundary with an average of 1,536 acres. The average oil in place is 357 million barrels and 28 million barrels of estimated ultimate recovery over the 40 wells. This leads to an expected recovery factor of 7.8% with 40 long lateral wells per DSU, and this is a reasonable recovery factor.
Finally, turning your attention to Exhibit Q, would you please explain the significance, what this shows and the significance to this hearing today?
Yes, this is a well economic comparison between the 330-foot setbacks and the 100/200-foot requested setbacks, and it just clearly demonstrates that the requested heel toe setbacks are economically justifiable.
And I'm going to refer you back to N3. And please explain to the board again what's the need for these drilling unit boundary wells from your point of view as an expert?
So the section line DSUs are needed to recover the resource and to prevent waste. We would intend to drill up to 5 stacked wells targeting each zone.
And that's because this 560-foot setback between the drilling unit boundaries, there would be a large gap of resources that wouldn't otherwise be recovered without those boundary wells. Is that correct?
That is correct.
All right, is it your expert opinion then, first, the establishment of the new drilling units and their development by 15,000-foot long lateral horizontal wells is supported by reservoir analysis?
Yes.
Is it also your expert opinion that the reduction of the heel-toed drilling unit boundary setbacks are necessary to recover additional resource that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the requested reduced setback should not result in adverse draining or waste and will be protective of the correlative rights of the adjacent owners?
Yes.
And finally, is it your expert opinion that up to 5 drilling unit boundary wells with a 330-foot tolerance on each side of the boundary line is required to recover additional resources that would otherwise be left in the ground?
Yes.
All right, Mr. Chairman, that concludes my examination of Mr. Wall.
Division?
The division does have a question for this witness. Dustin Doucette from the division would like to ask that question.
Yeah, Dustin Doucette, engineering manager for the division. I guess this is an exhibit I had the question on, this and N1. So what is the difference? You've got a fracture orientation of 78 degrees on this one versus 69 degrees on your average on N1. Is that because of our using the particular analysis you've got down closer to the boundary line there for this number, the 78 degrees versus your average up higher?
Yeah, so this is a 78 is more specific to that particular section. So basically, if you can look at the slide that Mr. Jennings showed that has the stress orientation on it, you'll see that it actually swings. It's changing direction. So as you go east, it flattens out a little bit, goes more east-west, and as you go to the west, it starts swinging a little bit north-south. So that's just depicting the,
Okay, that was the question I wanted answered, and you did. Thank you.
Oh, no further questions. Oh, we do have one more.
Sorry, Peter Pankey, geologist with the division. I just have a question about your 200-foot setbacks. So you have here outlined in the red are the 100 feet in the north and 200 feet to the south. Is that correct?
Yes.
And in your testimony, you explained how that's because of the angle of the DSU on the southern boundary that you're doing that. We just looked at that in N3, I believe in N2 as well. But I'm just curious, how come that 200-foot setback doesn't extend to the east one more DSU? Because that also has a boundary that's angled, has an angled boundary.
Jordan might be able to answer this, but I believe there's already an established 200-foot setback in that particular DSU.
Yeah, I'm assuming, and apologies if I'm not understanding the question correctly, but both of the DSUs shown in the red outline, currently the setback is 100 feet at the north and 330 feet at the south. And so we're just reducing the southern boundary. And so essentially, if you I know the colors here are somewhat hard to see, but if you look at the area that's shown for 130-14, it's both of those DSUs, and it actually extends, that order actually pertains to lands immediately to the west as well. So as it relates to this, both of the DSUs that are shown on this exhibit that are colored with the 130-14 are going to have the 200-foot setback under the request.
So does 130-09, does that have 200-foot setbacks on the southern boundary?
It does not. That currently has 100-foot, I believe.
Okay. Well, I'm just wondering why. So that one, I wish I had like a laser I could point there. But there's two green outlined units there.
Correct.
right? So the one to the west, it also has that angled, and this might be a silly question, but it also has an angled boundary on the southern portion. So I'm wondering why that doesn't also have a 200-foot setback, whereas the two also that are to the west have a 200-foot setback. Because in N3 you showed that because of that angled boundary,
correct,
there's going to be a drainage problem. But it doesn't look like that western green 130-9 is included in that request.
Yeah, I would say I wasn't a part of the 130-09 testimony, so I don't know what the justification was. We're essentially not changing what exists for that right now under this request, but I do understand the question.
Okay.
This well's been drilled. If you could give me a second here. I think that the intent is to make it the 200-foot across that boundary, if I'm not mistaken. Is that correct?
Yeah, that's correct. I mean, we do want uniformity here. I just think that what had occurred here is that we were only looking at the lands that were subject to the 130-14 because the 130-09 was already set at 100 foot. So I think if you go to the next exhibit where we're showing spacing at 100 foot, see, it was done previously under the 130-09, and so we effectively did not have any changes to it under this present request.
Okay, so everything that has that boundary that slopes, we'll call it southwest to northeast, should have a 200-foot setback.
Right, and we would modify whatever we need to do for the request to make that consistent.
Yes.
Okay. Thank you.
No further questions from the division.
Any questions from the board for this witness?
Yes, could we look at Exhibit N3 again? Okay, never mind. I'm good. I was confused for a second, but good. I'm good.
Go to N1, please. So I understand we're not modifying the 560 boundary, the east-west setbacks. But this goes back to my prior question in the prior request. So it appears from this there's plenty of buffer room between for that 560-foot setback provides plenty of room, so there's not going to be no drainage from the neighboring section, correct?
That is correct, yes.
And so if that's the case, why wouldn't you feel comfortable putting, and you also have in Exhibit P 8 wells presented, per interval as ultimately available. So, but at this point you're doing 4. So just that same question again. I apologize. I keep hitting the same thing, but why not put them 560 feet apart, where you're demonstrating here that there's not going to be interference between the wells?
I think there might be a couple of parts to that, and I apologize if I misunderstand your question. But as it pertains to the distance between the section lines, I want to make sure it's clear that we do intend to come back with a drilling unit between those, the 330 foot. So there's that question. And then the density question is a whole nother one. And we had that discussion in the previous hearing, and so we're still exploring it, but what we do have is the option to come in here and drill at 560 foot spacing. We don't know if that's the most efficient way to drain the resource here, but we're definitely studying that. And right now, we're pushing our density up to 5 and see how that works for us. Because there can be an economic waste, right? So we could drill too many wells and be sub-economic. We'd lose money, right? So we have to balance those the risk reward there.
Okay, so right now you are drilling them at like 1120 so that you do have that opportunity to go back in at 560 spacing and get the 8 versus the current 4. Am I understanding
That's
that
correct.
correctly? So you're leaving that opportunity.
That's correct.
Okay.
Yes, Mr. Church.
This question may be for Mr. Lair. Would you please help remind me, are all the wells in this entire RAA subject to conversion, the existing wells across the board?
That's correct.
So old vertical wells and also the horizontal wells?
Yes, sir.
Okay, thank you.
Mm-hmm.
Any other questions? Seeing none, back to you, Mr. McDonald.
Thank you, Mr. Chairman. At this time, I would move for admission of Exhibits A through Q inclusive.
So admitted.
Okay, and I'll reserve closing remarks after the division has made its statement.
Division, the time is yours.
Thank you. The division has reviewed this request, and we have gone through all the exhibits and listened to the testimony today. And based on what we've reviewed and heard, the division is satisfied that this request meets the regulatory requirements that we're asked to review. And with that said, the division does not have any opposition to this request. Also, numerous people were notified of this action today, and we are not aware of receiving any objections to that. However, today we are aware that somebody representing Dominion Energy who did receive notice of this would like to make a comment as to this request, and will the board allow that comment?
Yes.
Just right here, and if you hit the button, it'll turn green.
Thank you to the board and the division and the party for allowing us to quickly comment on this matter. Dominion became aware of this filing just recently and took a little bit of time for it to identify what its interests were in the area, and we wanted to just appear to clarify what those interests are. Dominion does have pipeline infrastructure under the ground. It doesn't have any objection to the substance, but just wants to notify the board and also the party that they will need to go through the blue stakes process and make sure that there is no interference with the pipeline infrastructure in the area. We request that the board consider entering in its order the language that's identified in Utah Code 54-8A-3.5, which provides that an entity issuing a permit for building or construction that may require excavation may and is encouraged to include a notice on or with a permit stating, attention, Utah law requires any excavator to notify the owner of underground facilities 48 hours before excavating and comply with Utah Code Title 54, Chapter 8A, damage to underground utility facilities.
Could you, just for the record, state your name and business address?
Sorry, yes. Maria Wyndham. I'm an attorney at Ray Quinney and Nebaker. The address is 36 South State Street, Suite 1400, Salt Lake City, Utah, 84111.
Okay, thank you. You finished? Because that was fairly substantive, I just want to make sure there's no objections on.
I would ask, doesn't the division do that anyways in its permitting?
We deal with the permitting the wells. We don't deal with infrastructure. However, if there's no opposition to this being that it was noted that there was a request.
It's noted, again, the permits that are done with this is, unless it's a zoning thing or something like that, I'm not aware, but I would assume the company is very aware of the fact that they do not want to interfere with infrastructure.
Okay.
Yeah, I don't have anything further.
Okay, thank you.
Thank you.
Back to me, Mr. Chairman.
You're done, division?
All right. Yeah, the division just wants to note that we don't administer that rule as we stated. However, being aware of that, we have no opposition to. But with that said, we, as I mentioned earlier, we have no opposition to this request. And with that, we are done with our presentation.
Thanks. Just any follow-up questions for the division before we go back to Mr. McDonald? Okay. Okay, Mr. McDonald.
Thank you, Mr. Chairman. With that, again, the division has shown anything. I think the testimony that has been provided here has justified it. I think it has been somewhat expressed by the board that they wanted to see a uniform development plan. That's what Ovin have provided today. They've met all the requirements for it, and we would ask that the board grant the request as submitted. And with that, also on a personal note, I'd like to wish you all a happy holiday season, and to the division staff as well.
Thanks to you as well. Was your question or?
I think it's more procedural. I'm not sure how we handle the Dominion request on the RAA.
It was a public comment, and I think we are going to just step out also before
Okay.
a vote. We can talk about that a bit more. Division? Any final words of wisdom?
Just also a Merry Christmas as well. But
Okay, well,
other than
that's
no.
very wise, and
No
we
more.
wish you all a Merry Christmas. Before we take a vote on this, I think we should just adjourn briefly for some consultation, and we will return as rapidly as we can. Thank you. We are back. Thanks for your patience. I would entertain a motion on this issue.
I'll make the motion that we approve the RAA as presented, but also make sure to include the 200-foot setback on the southern boundary.
That's the southern boundary that's not oriented east-west.
That's not.
I know what happened.
I'll second the motion.
Any last comments?
Yeah.
All those in favor say aye.
Aye.
Let the record show that was unanimous. And Mr. McDonald, could you please draft the necessary documents?
Certainly. Thank you.
Thank you. It's afternoon, so, and I know our lunch is here. I would propose we take a lunch break until 1 o'clock, and then we take care of the last issue today. We are off the record, and we'll see you all in just under an hour. Welcome back. We are on the record, and we are ready to move on to our last docketed item, which is docket number 2023-049, cause number 076-04, in the matter of the notice of agency action requesting the board issue an order forfeiting the bond covering wells identified as 27-2 API number 43-007-30939, 27-4 API number 43-007-03940, and SWDI 1 API number 43-007-30979, and directing the division to orphan, plug, and reclaim the well sites. I'll now ask for appearance of counsel.
Sorry, I didn't have it on. Should I do that again?
Yes.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining.
All right. Well, seeing you're the only one, the only attorney here, I think you should start off.
All right. Thank you, Chairman. In this notice of agency action, the division requests that the board issue an order forfeiting the bond covering 3 wells, 27-2 API number 43-007-30939, 27-4 API number 43-007-03940, and API number 43-007-30979. The division also requests that the board direct the division to orphan, plug, and reclaim the subject wells, and further requests that the board direct the division to recover costs incurred by plugging and reclamation against the operator, Emory Resource Holdings, in the event that the bonds are insufficient to cover the costs. The board has jurisdiction to hear this matter under Utah Code Annotated Section 40-6-5. The administrative rules govern the proceeding here. Rule 649-336 indicates that wells cannot be shut in or temporarily abandoned for more than 12 consecutive months without the division's approval. Under that same rule, wells must be plugged after 5 years of non-productivity. And if after 5 years of non-productivity the division orders the well plugged and the operator does not comply, the bond must be forfeited and the well properly plugged and abandoned pursuant under the division's direction. So with that introduction, if we could, I'd like to have Mr. Payne sworn in as a fact witness.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
With your permission, Chairman, I'd like to just recite the background facts, and then I'll ask Mr. Payne to confirm that those are correct.
Yes, please proceed.
Okay. So Emory Resource is the operator of the subject wells. Those are located in Carbon County, Utah. The subject wells have not produced since at least 2015. In the year 2021, the division issued a notice of violation requiring Emory Resource to either produce or plug and abandon the subject wells by a compliance deadline. And the notice of violation indicated that if they did not do so by the deadline, they would incur civil penalties. Emory Resource failed to abate the violations, so the division escalated the matter to a division enforcement order. And this ultimately resulted in a final civil penalty assessment of $600,000, which was entered on June 13th, 2022. Eventually, Emory Resource requested informal review of the penalty assessment, and that informal hearing took place on July 19th, 2022. At the hearing, Mr. Williams, who is the CEO and president of Emory Resource, and the division indicated that they would like to engage in settlement negotiations. On August 8th of 2022, the division and Emory Resource entered into a stipulation and consent order. The agreement was threefold. One, to plug the subject wells by October 14th, 2022. Second, to submit all required plugging reports by November 13th, 2022. And third, to complete all surface reclamation by April 14th, 2023. The presiding officer at that hearing approved the stipulation and entered the order. Unfortunately, over the next several months, Emory Resource failed to take any additional steps toward plugging the subject wells. So on December 15th, 2022, the division filed a status update with the hearing officer and requested that the wells be allowed to transfer. This took place because the division was informed by Urban Oil and Gas Group that they had some interest in taking ownership of these wells. So in light of these events, the division requested that the presiding officer modify the order to allow the subject wells to be transferred to Urban. Alternatively, in the event the transfer did not occur within 90 days, the division requested that the presiding officer direct the division to orphan the subject wells, pursue administrative penalties against Emory Resource, and thereafter allow the division to transfer the subject wells from the orphan well program to Urban. There was a status conference held on January 4th, wherein it was reported that the division reported that Mr. Wells had not notified the division that he did not intend to follow through with the stipulation he had made. And the division further reported at that status conference that Mr. Williams had avoided communication with the division, not responding to emails or telephone calls. Mr. Williams did report that he had tried to find new ownership for the wells. Therefore, the division asked for this transfer of the wells, but there had to be an administrative complete change of operator form submitted to the division within 90 days. The presiding officer ordered that and ordered that the administratively complete change of operator form be filed on or before July 1st, 2023. Emory Resource, in the meantime, was informed that if the operator form was not filed by that date, that they would be in violation of the order and that the division would take the steps necessary to ensure the subject wells were properly plugged and abandoned. As outlined in the order, such steps included seeking bond forfeiture, orphaning the subject wells, and seeking the costs that weren't covered by the bond. Although the July 1st deadline has now long since passed, Emory Resource has failed to file an administratively complete change of operator form. Additionally, upon information and belief, Emory Resource has failed to take any steps toward plugging the subject wells. So, Mr. Payne, I would ask you, is the recitation of facts given to the board true and accurate as far as you know?
It is. There are a couple things I do want to add prior to the NOV that was issued in 2021. First, there was a shut-in extension letter that was issued by the engineering group under Dustin Doucette here. That was in January of 2016. A second shut-in letter was again issued in October of 2017. And then a first NOV was issued in September of 2020 and reissued in 2021 under the new penalty rule after the legislative group had passed it. Other than that, everything else is true.
Yeah, thank you. The board should know that there will be a deficiency in bonding in this matter. Of the 3 wells, there are only bonds covering 2 of them. That would be API numbers ending in 30939 and 30940. There's $30,000 for each of those wells. API number 30979 has no bond attached. And we submitted this in the exhibits prior to the hearing today, but the total amount estimated to plug will be $228,020. So there will be a deficiency here of around $168,000 based on the estimates. I would note for the record that Mr. Williams, the CEO and president of Emory Resource, is here. He's informed me that he does not plan to address the board today. However, I just wanted to make that clear that he is present. Now, based on the evidence and the rules that have been cited, the division would ask that the bonds covering the subject wells be forfeited, and that the subject wells be orphaned, and that the division be directed to plug and reclaim them, that the division be allowed to collect costs incurred by plugging and reclamation against the two bonds totaling $60,000. And finally, that the division be directed to recover from Emory Resource, the operator, any costs of plugging and restoration in excess of the bonded amount forfeited.
Thank you for that. Are you ready for questions?
I think that's all I have. So yes, any questions, please?
Board, any questions? Yes, Mr. Church.
So I'm interested in the saltwater disposal well that has no bond on it. Was it ever a producing well that had a bond on it that you're aware of?
Mr. Doucette from the division can answer that.
Yeah, Dustin Doucette, engineering manager. That well was a federal mineral well, and at the time, we thought the feds had bonded that well. Subsequent, we found out that they did not hold bonds for plugging and reclamation of that well because it is a saltwater disposal well. So it was never permitted as a producing well, so did not have bond through us on that well.
So it's not on federal lands, it is on federal lands?
It is on federal lands, yes.
And what obligation does the BLM have with that kind of situation?
I think that's covered under their surface group, not under their mineral group. So that's why it kind of did not get bonded through their mineral group.
Okay, thank you.
Any other questions?
Why aren't the feds plugging that well?
I think because we have UIC jurisdiction on that, we'll probably still have some communication with them, but I had reached out to them and in the last year or so, kind of find out what kind of bonds they had and
chip in a little bit here?
Yeah, and so we'll probably continue to have some of those discussions, but I think their take on it was definitely in the mineral group, it didn't penetrate federal minerals and was not producing well, so that's why.
Is it federal surface or fee surface?
I believe it's federal, so, yeah.
What happened to the $600,000 assessment?
That assessment is due in owing, but it has not yet been collected. So that's something that the division will be working on.
And did those wells ever produce? Do you know if they ever produced anything?
Yes, they produced consistently until Emory Resources took them over. So I'm trying to remember the previous operator's name, but they definitely had produced consistently prior to them taking over in the 2014 timeframe.
Thank you.
2013 maybe.
I can just speak to that. Those wells produced up until 2013 for one of the wells and 2014 for the other well. Then after that, there was no production.
Any more questions?
So what's the process when a well that's late in its life is being transferred to a new operator? You just require bonding from the new operator, and you just kind of discuss that a little bit, because, yeah.
Yeah, so in most situations where we have, like if there's an idle well being transferred, we're definitely looking at that hard and making them put up additional bonding on those wells. The case in these wells where they were producing up until that operator changed, so we didn't have that situation when we transferred operatorship to Emory Resources. But in general, we are looking at those. The new bonding rules we're looking at will also kind of take care of some of these issues that get kind of lost in some of these loopholes we've got in our bonding rules currently.
That was going to be one of my questions. Under the new bonding rules, would we have avoided this shortfall in funding? Huh?
Yeah, I think we would have, based off of the amounts are getting higher as well. And I can just mention a little bit on the bonding. That total amount that Gary had mentioned, and you saw the exhibits, Exhibit 7. We do have, some contingencies built into some of those costs. And I do have a mob cost that's included in there that's at about $40,000. Now, that's probably the extreme. Coming from like Farmington, New Mexico, we could be a little bit lower on that. So in general, it's about 50 to 60,000 based off of our history out here and based off our estimates. That's basically where they come in. And those have shown to be pretty accurate. The saltwater disposal well is a little bit higher, but we're not too far apart on the 30,000 to the 50,000, but the fact we have one well that doesn't have bonding, that's probably where the biggest deficiency is. But I think as far as the rule's concerned, I think we are upping those bond amounts, so that'll cover it. If you have a marginal well, you'll be required immediately to get some of that money in place, like increased bond in place. So I think that will help out our efforts as well.
Just one other thing I wanted to add in conjunction with the question that Mr. Moon asked is the operator change happened in 2012. So these wells were producing at that time after the operator change. They produced for about a year to 2 years. So they did fit the current bond, which is why they were assessed at the rate that we have them bonded at.
Do you have pretty good competition with contractors to plug these wells, or are there just very few operator or whatever you call them out there, contractors out there?
I mean, we usually have, it depends on how busy things are out there, but I mean, we typically have 5 or 6 people, and they're people that are doing business in Utah consistently. A lot of the operators are using them, so typically they're going to be bidding on them. There's not typically a lot of difference between the bids that come in, so they are going to be what they are. So I mean,
it's not all the same company with the different names.
Yeah, no.
Yes.
Just a question in general on orphan wells. Are there any costs recoverable from used equipment when on these P&A estimates? And if so, does the division market out that equipment?
A lot of the ones we've plugged to date haven't had much usable equipment, and it's been more, we get credit for basically hauling it away, is what it's been. There are a couple wells that we have on the list, or at least one on the list that we are considering going a separate contract to basically bid those out, or to basically sell that equipment to help make up the difference. I'm not entirely sure what we've got on these wells in particular, but that could be an option. The other thing we run into are usually in these cases, they're deficient in their taxes with the county, so there are usually sheriff sales involved and other people wanting money for that surface equipment because they haven't paid the taxes on it. I think this went through a sheriff sale at one point in time in 2017, but we typically try to work with the counties on that and see what we can do as well. But that's a potential. If we've got something worth anything out there, we could potentially do a separate contract just for marketing those, because our contractors for P&A typically aren't in that business, so it's hard for us to make anything on that.
Dustin, you're an engineer. Maybe you got to produce some of these wells and get some money coming in. You're going to pass on that?
I'm going to pass. If you guys want to order that, maybe. But.
So, just so I'm keeping up, even though it was federal surface and federal minerals, since it was under the UIC program, the state, that's where it fell through the gap, so to speak, while the state's being responsible for reclamation?
Yeah, I don't know if I can really answer that question, why that is kind of fallen through. I mean, I think it's still something we need to get with the BLM on as well and just kind of see where we're at.
Yeah, so the SWD, the injection well, it's under a state primacy program, which means that for the administration of it and the bonding, it falls under the state. There may be some type of right-of-way agreement with the land manager, rather it be whatever federal land agency. But as far as the well, because it is a UIC program and it's a primacy well, then the obligation to plug it falls within the state.
So I guess that's my next question then, is that are there other wells like that out there that are falling into the same condition that aren't bonded? Have you done a search that, is this a one-off, or have you done a search that there's other situations like this?
Yeah, no, anytime that you have a well converted from a producing well into an injection well, there is a potential for it to lack bonding. We have done a search on this, and as Mr. Doucette indicated previously, that's one of the things we're focusing on as we go into the bonding rulemaking with the stakeholders, is to specifically address this situation so that as we have disposal wells in the future, we don't run into this scenario where they're not covered by financial assurance.
And then is it part of the bonding exercise that it's reviewed on each bond comes up on a certain frequency to be reviewed again, or is it a one-time?
We're working towards setting that up for a 5-year review, but currently it is a one-time.
Garrison.
Utah has an orphan well fund, don't they, that gets money every year? Is there money in that fund to plug these wells?
Yeah, we've got money in the fund, and it doesn't automatically go into the fund every year. We have to request additional money to go in there, but
so it's not lapsing?
no,
So you have to,
it's
every year you have to.
It's a protected fund that is ongoing. Yeah.
So it's not, you're not taking money away from any other program to plug these wells? It comes out of the orphan well fund?
Correct. The money comes from the 2 mil levy on production that also funds our program, or partially funds our program. So that's where the money's coming from. It's coming from operators producing in the state of Utah.
Okay, great. Thank you.
Last production, 2015, so over the past 8 years while these have been sitting idle, have they been posing any threat to public health, safety, or the environment in terms of wellhead gases escaping, interconnections between different aquifer and reservoirs, those sorts of things?
So the inspections on these have been consistent through that time frame to ensure that none of that has been taking place. Excuse me. And that's why the violation that essentially went out was for the shut-in rule and the shut-in rule alone. And they did have, there was an MIT that was passed on the saltwater disposal well to make sure that there was downhole integrity. And then the others, they did file an extension request that was denied because they didn't meet the rule requirements. But aside from that, it's basically just shut-in extension is the rule for lack of production that they haven't followed.
Thank you. Any other questions from the board? Seeing none, back to the division for summing up.
Thank you. So based on the evidence and the rules that apply here, again, the division would ask that the board forfeit the bonds covering the subject wells, orphan the subject wells, and direct the division to plug and reclaim. Direct the division to collect costs incurred by plugging and reclamation from the 2 bonds outlined in the papers. And finally, directing the division to recover from Emory Resource any costs of plugging and restoration in excess of the bonded amounts forfeited. And with that, I would submit it.
Thank you. Just a housekeeping thing. In your opening description of the issue, it sounded like you did kind of walk us through exhibits 1 through 10, though you didn't specifically reference them. Just
yes,
because they're offered as evidence, and we should
yes.
put them as evidence.
Yeah, and I would move that the exhibits submitted. I actually think it goes from 1 through 10. Okay. We'd move to have those admitted.
So admitted.
Thank you.
Yes, Mr. Moon.
Maybe it's more of a comment, but toward the end here, we started talking about, we have the money to take care of this and where it comes from, and one could kind of leave here feeling like, or thinking that, well, we've assumed that responsibility, but you did state in your, request for our order that that money be recovered from Emory Resources.
Correct.
And you have the penalty, which way exceeds, the plugging costs. And then you have also, any incremental plugging costs. So just kind of what's going to happen next? I mean, how will that money be recovered or attempted to be recovered from Emory Resources?
I think there's two parts to that, Mr. Moon. The first is as it relates to the costs associated with plugging. The work will be done. There'll be hard numbers, and then there will be a deficiency that will inform what amount is owed from Emory Resource. The civil penalty is a separate issue. That amount is due and owing as of today, and the division is taking steps to work with Office of Debt Collection to recover those funds.
Okay. So it will come out of the division's pocket. Is this going to happen? And then
the bond money will be collected, and then there will be a deficiency.
Okay.
And then Emory Resource, as I understand the process, will be asked to pay the difference.
Okay.
Did I get it right?
Yeah.
Thank you.
Do we need to step outside to consult, or should we entertain a motion?
Alan, have a question?
Alan?
Yeah, I was going to ask, do we know if Emory Resources has the capability, or if Mr. Williams has the capability to pay the deficiency? Or,
I mean, I haven't seen the books or the papers. I spoke to Mr. Williams earlier today, and it's my understanding based on that conversation that there may be some resources available.
Again, do we need to consult, or are we prepared to entertain a motion? I agree. To me, it's fairly clear-cut what needs to happen here. So I would entertain a motion.
I make a motion that the notice of agency action be approved as requested.
I'll second that.
All those in favor say aye.
Aye.
Aye. Let the record show that was unanimous. Could you prepare what needs to be prepared in this case? Any documents that are necessary?
Absolutely.
Thank you very much.
Thank you, Chairman.
Yes, Acting Director.
Well, that was the last matter, right?
There is one more matter.
Oh.
But
Well, sorry. Go ahead.
okay.
I thought that was the last matter.
No, we're sneaking one more in.
Oh, okay. Go ahead.
As many of you are aware, every year about this time, the board votes and decides who will be the chairman for the upcoming year or years, and that we did discuss during lunch that exact issue, and I'm pleased to announce there will be a new chairman this coming year, and I guess do I entertain a motion for the chairman and vice chair that we agreed upon?
Probably need to tell them the names.
Oh, he was going to say the names.
Okay.
In the motion, huh? Go ahead.
I'm spacing names out now.
Okay, well, I can't make the motion.
Mr. Chair, I make a motion that our new chairperson be Levon Garrison and our new vice chair be Al Walker.
That sounds like a very sound choice. I'm pleased. And second, all those in favor say aye.
Aye.
Aye. Let the record show that was unanimous.
Okay, I was tipped off that was happening, and that's actually the matter that I came up here for. Chairman, board, and the division would like to thank you for the service that you've given over the last year as the chair. Almost exactly a year. I think December 7th last year was your first meeting as chair, and you've been a very good chair. You've kept meetings on track. You've been very engaged. I've worked with you on some legislation over this summer that was kind of frustrating, but we've learned a lot, and hopefully we're moving forward on that with the minerals legislation that we're working on. I know we're going to have another meeting today on some matters along those lines, but from the division, thank you for all the work that you've done as a chair over this term, and we look forward to working with Ms. Garrison as the new chairperson and Mr. Walker as the new vice chair. So thank you again. We just want to recognize that service that you've done. We know that you still have time on the board, but we know that the chair job is one that takes up more work and time, and we appreciate the work that you've put in, and thank you from the division.
Thanks for those kind words, and I'm looking forward to just being the member with knowledge of mining matters.
I'd like to correct Mr. Borden. We're going to, for mining matters like this that are ongoing, we have asked him if he would continue to be the contact and work on those things. He's very well versed in all the mining issues, so there will be continuity there.
Good.
And not switching
okay.
people. Thank you.
Thank you. I'd entertain a motion to adjourn.
Make a motion to adjourn.
We are so adjourned and off the record. Thank you.
I'll talk to these gentlemen about it. Hey, safe travels to you. Thank you. It's nice to have you. Okay, nice. I don't. I think you got a lot better about this one. No, it was much better. Okay, good. The fees were like any paid attention. Going over.